Hello, welcome to another installment of our series, Managing Your Practice, Managing Your Exposure. My name is Eric Cooperstein. I have a solo law practice in Minneapolis, Minnesota, devoted to representing lawyers in legal ethics matters. Mostly I defend lawyers who have received ethics complaints. I also give advice to lawyers. I represent lawyers when their law firms are breaking up, and I do some expert witness work. Earlier in my career, I also worked for our state disciplinary agency that investigates and prosecutes lawyers for ethical violations. So all of my discussion in this webcast is around what I have seen lawyers doing in their practice over about a 10-year period. This program is called Happy Trails, Terminating the Lawyer-Client Relationship. What we'll cover in this program is how to plan for withdrawal, planning for the end at the beginning of the representation, how to handle the most typical withdrawal situations, what should be included in the client file when you return it to your client, and common recommendations for retention of your client files after the representation has been concluded. So, planning for withdrawal from the outset, kind of an odd concept, but you should think about how you will end the representation when you begin it, because there are steps you can take early in the representation and notices you can provide to the client that will help make your withdrawal or termination of the representation cleaner at the end of the case. So, there are provisions that you can put into your representation agreement that address end of matter issues. For example, you should put into your representation agreement a provision that says that if you fail to pay my fees, or if you fail to cooperate with my representation, I may withdraw from your case. Now, that's a part of the model rule.